Good morning. Good afternoon. The Appellate Division First Department is now in session. Welcome to our virtual oral argument. I will now call the calendar. The first case is People versus Franklin Johnson for the appellant.
Good afternoon, Your Honors. Jan Hoth for Appellant Franklin Johnson.
Okay, you have 5 and 2. For the respondent?
Good afternoon, Philip Tisney for the New York County District Attorney's Office for the respondent.
You have 5 minutes. McGregor versus MRMD for the appellant.
Good afternoon, Your Honor. Adrian Uran, felon indictment for the appellant.
You have 5 and 2. For the respondent?
Good morning, Your Honor. Steve Arapach from O'Dwyer and Bernstein for the cross appellant, plaintiff Shannon McGregor.
Okay, you have 5 and 1. The next case, Gabriella versus Joe, is submitted. Penna versus Integrate Manhattan for the appellant.
Brian Isaac for the plaintiff appellant and respondent, Your Honor.
Okay, you have 5 and 2.
Thank you.
For the respondent?
For the respondent appellant, Your Honor, Michael Safranek.
Okay, you have 5 and 2. And the other respondent?
The respondent, Greg Beach Logistics, Kevin Fitzpatrick, Woodsmith, Henning and Berman.
You have 5 minutes. The next case is Amaya versus Purvis Holding, which is submitted. Garda USA versus Sun Capital for the appellant.
Your Honor, Martin Roth on behalf of the Sun Capital appellants.
You have 8 and 3 for the respondent.
Good afternoon, Your Honor. Michael Garvey, Simpson Thatcher for respondent Garda USA.
You have 8 minutes.
Thank you.
Your Honor, this is Rahul Mukhi. I'm also here for appellant SOS Ultimate Holding.
Okay, but you didn't request any time, correct?
We requested and was granted time. Sun Capital, represented by Mr. Roth, has 8 minutes, and I have 3 minutes on behalf of SOS, according to the community.
Okay, it's not for rebuttal time, it's for you. Okay.
And Your Honor, for Sun Capital, may I request of my 8 minutes, 1 minute for rebuttal? So 7 and 1, and then Mr. Mukhi has his 3 minutes.
Sure.
If Your Honor, I could also request 1 minute for rebuttal, so 2 and 1. Thank you, Your Honor.
People versus Delgado.
Jody Ratner for appellant Jimmy Delgado, and I also would like to reserve 1 of my minutes for rebuttal.
Okay, you have 3 and 1 for respondent.
Noah Shamroy for the Office of the District Attorney of Bronx County for respondent.
You have 4 minutes.
Thank you.
Avalon Automotive versus Leontief for the appellant.
Good afternoon. Good afternoon, Your Honor. Sean Hecker for plaintiffs appellants, Avalon Automotive Group and Karan Avagumian. We've requested to reserve 2 minutes for rebuttal.
You actually have 8 minutes and 2 minutes for rebuttal.
Thank you.
Respondent?
Yes, Your Honor. Good afternoon. Robert Weigel from Gibson Dunn. I represent Sergey and Leonid Leontiev.
Okay, you have 8 minutes. Razak versus Juno Inc. is submitted. People versus Carey, appellant.
Allison Kale on behalf of the defendant appellant Hubert Carey.
You have 6 and 2. Respondent?
Vincent Revelisi for respondent New York County District Attorney. Good afternoon.
Good afternoon. You have 6 minutes. Hyatt versus Queens West.
Good afternoon, Jonathan Chow for the defendant's appellants.
You have 5 and 2. And for the respondent?
Good afternoon, Justice Kern. I'm David Perisman. I'm here for the plaintiff respondent.
Okay, you have 5 minutes.
Thank you.
Deutsch versus Deutsch is submitted. Jones versus NYCTA for the appellant.
Yes, good afternoon, Your Honor. Stu Carlin for Jerry Jones. I think I have 5 and 1.
You did. You have 5 and 1. Respondent?
Good afternoon, respondent, or Daniel Chu for the respondents.
And you have 5 minutes. Ryan Lee Properties versus City of New York, and this is for both cases. For the appellant?
Yes, good afternoon, Your Honor. For petitioner Patrick Kilduff, we request to reserve 1 minute for rebuttal.
Okay. And for respondent?
Yes, good afternoon, Your Honor. Elizabeth Friedman, appearing for respondents.
Okay, you have 5 minutes.
Thank you.
Clear Channel versus City of New York for the appellant.
Yes, Your Honor. This is the related case to Ryan Lee Properties. So it's Patrick Kilduff for petitioner. We had again would reserve the 1 minute for rebuttal with the idea that perhaps we could have this all done under the Ryan Lee time for argument.
Okay, so I'm going to give you time on both cases, but if you don't need it, because they really are extremely similar arguments, we could just waive your time in the second case. For the respondent?
Yes, Elizabeth Friedman, Your Honor, appearing for respondents in the Clear Channel case as well, for the City of New York et al.
Minutes, but if we don't need that, then obviously you can waive that time. 2001 Real Estate versus Stone Land is submitted. Busher versus Barry is submitted. I would ask that everybody keep their microphone muted while you're not speaking, and that will make it much easier to hear everybody else who is speaking. The first case is Johnson, and we'll hear from appellant.
Good afternoon, Your Honors. Jan Hoth for appellant Franklin Johnson. Unless the court has any questions with respect to points 1 and 2, I would like to proceed directly to the sentencing issue. Mr. Johnson clearly stands convicted of a serious crime, but there are several mitigating factors that suggest that a crime less than the maximum would be more appropriate here. Maximum sentences should be reserved for the most serious offenders, a designation that clearly does not apply to Mr. Johnson. As even the prosecution concedes, Mr. Johnson's criminal activities are fueled by severe mental health issues. He's been diagnosed with schizophrenia. He has mood disorder, depression. He's currently, or at least at sentencing, was on serious antipsychotic medication, as well as what probably just flows from that is drug abuse problems and addictions. That has fueled not only this crime, but his criminal behavior in the past. As contrary to what the prosecution suggests in their brief, however, extended incarceration is not the proper forum to get him treatment for these problems. It's well documented that extended incarceration only exacerbates mental health issues. It's not helping him, nor does extended incarceration act as a deterrent. It clearly hasn't in the past.
Counsel, this is Judge Owing. Did your client challenge the second felony? Now, unless I'm mistaken, did he get sentence was imposed as a second felony offender?
Yes, Your Honor, it was.
Did he challenge that predicate?
No, he did not, Your Honor.
What's the minimum on this? I forget.
2 to 4.
Thank you.
And he got the maximum of 3.5 to 7, and the crime occurred in 2016, so he's already been in for close to 5 years. So even if this court weren't to reduce all the way down to the minimum, but somewhere in the middle, it would still put him closer to release, where he could get the treatment and the rehabilitation that he needs. Right now, this sentence is serving only as punishment, and punishment is ineffectual in helping the problems here. Again, just look at the nature of the crime. This was not, it was fueled by a desire for money. It was serious, yes, and it's designated as serious, but he threatened a knife, but he never showed a knife. He didn't have a knife. He said vile things to the complainant, but he never touched her. It did not make any attempt to stop her from running away when she desired. So we can consider it a serious crime, but Mr. Johnson is not a serious offender who deserves the maximum.
Okay, let me hear from respondent, and then you'll have 2 minutes for rebuttal.
Thank you.
May it please the court, Philip Tisney for the respondent. I might regret this, but I'll go ahead, and unless the panel have any questions on the weight and the suppression point, I'll move to the sentencing issue as well. The only things I'll note on that point are that, as Justice Owen pointed out, his minimum in this case was 2 to 4. He got 3.5 to 7. He was parole eligible last year. The parole board denied parole. So if adjustment to a confined environment was something that was going to benefit him, apparently that has.
So what was the second felony offender based on? What was that predicate based on?
I don't have them in front of me right now.
No, I didn't see that either.
I don't have them to hand. I know that there was a prior attempted robbery, and I think the other one was an attempted assault, but I'm guessing at this point.
But at sentencing, he never challenged the predicate, correct?
No, he didn't. So like we said, the lowest he would have gotten was 2 to 4, which is really only a year off what he got now for his parole eligibility. The other point, just to correct one thing that counsel said, when she said he didn't try to stop her when the victim, when she ran away, he chased her, after threatening her with an undisclosed knife, or at least pretending that he had a knife, and then saying all these vile things of a sexually aggressive nature. She ran away and he chased her down to the door of her apartment. So it's not exactly like he let her walk away unmolested. Unless the panel have any further questions, we're happy to rest on the brief and ask that you affirm the conviction.
Thank you very much. You have 2 minutes for rebuttal.
Yes, I'm not sure what the predicate was for, but Mr. Johnson had a 1997 conviction for robbery, a 2009 conviction for attempted third-degree robbery, and a 2012 conviction for burglary. So one of them would have served as the predicate, and if we went to, this crime was 2016, so there wasn't even a tolling issue. The attempted robbery, according to the pre-sentence report, or Mr. Johnson himself, was an $8 robbery. And to say that he chased the complainant down is a bit of a stretch. She ran away. She said when she got to her door, she turned around and she saw him. Considering that he was following her pretty closely while, saying undisputably vile things, it would not have taken much for him to catch her had he been so desirous of doing that. None of his prior crimes actually, although some were designated violent, actually involved any violence. Like here, he said a lot of vile things. He threatened things, but he never acted on any of them. He wanted money. He was homeless. He's a drug addict. He needed another fix. He needed something to eat. And that's been his pattern. And
thank you very much.
You're welcome. Thank you.
Okay, we'll hear from McGregor, appellant.
Good afternoon, Your Honors. May it please the court. Adrian, you're on. Call an indictment for appellant defendant. There are really 2 issues on this appeal. The first one is plaintiff's belated self-standing post-summary judgment motion.
I'm having a little trouble hearing you with your audio. I'm not sure what's going on.
Oh, sorry. Can you hear me?
Now we can.
Okay, I'll just move my phone closer. Technical difficulties today. So the first issue is plaintiff's belated affidavit, served for the first time in opposition to my.
Counselor, this is Judge Singh. Can you hear me? Counselor?
Yes, I can hear you.
Okay, so my question is I assume you're arguing that there's an inconsistency between the deposition and the affidavit, correct?
And also between his bill of particulars.
Is there an inconsistency in your view between the EBT and the affidavit?
Yes, there is, Your Honor.
And how is there an inconsistency in this case?
Well, first of all, the affidavit says that the workers would have been holding these purported taglines if they existed.
Right. So
but the testimony said the workers were busy doing other things. There was no hoisting going on. That's clearly inconsistent.
Sorry, counsel, please. Was he asked at the deposition by you or someone from your office whether or not there was a tagline on the on the beams?
Your Honor, he was not asked, and the reason for that is he didn't allege any bill of particulars. In the bill of particulars, he alleged lack of safety belts, landers, stable platform, railings, fall protection. He never alleged any taglines in the bill of particulars.
Well, isn't it
no
undisputed in this case that in fact there were no taglines?
Correct, but that brings up my second point, and really the more important point, which is lack of proximate cause. Simply showing that there's a missing safety device is not enough to establish liability under the labor law. The labor law requires a showing of proximate cause, and that's for either 240 or 241. In this case, there's absolutely, it's simply unrealistic. That showing of proximate cause has to be construed with a common sense approach to the realities of the workplace. That's a holding by this court, DeRosa v. Bovis, 9683D 652. The reality of this workplace was the hoisting had stopped, and all of the workers were busy fixing a fence that was an immediate hazard.
Can you hear me?
Yes, I can, Your Honor.
Sorry, I don't know if I was audible before.
I'm sorry, I'm having, I can hear you, but you're very soft.
The taglines would have stabilized the load, correct?
Only if there were workers available to hold it and prepared to hold it.
That's for sure, but I mean, that's part of the safety device. Is you can't have taglines that aren't secured anywhere or held by anyone. So the absence of workers does not seem to me to help your client.
Your Honor, the hoisting had stopped because the workers were doing something else. There could have been 100 taglines there. This accident happened in a second. Plaintiff testified it happened in a second. Even if there had been taglines there, even if the workers had been standing ready to grab them, this accident happened in a second when no one was ready or prepared to guide this load. So whether there was 100 taglines and 100 workers, it still couldn't have prevented this accident. And that's where the proximate cause falls down.
But the plaintiff was relaying messages to the crane operator, correct, via his supervisor, and then the supervisor, his name was Gus, I think, was called to do something else because there was this storm in progress that was making everything very difficult. So, I mean, there was work being done to this load at the time of the accident.
Your Honor, that's not the testimony. The testimony is the work had stopped and the foreman was not signaling the crane operator precisely because the work was stopped and the workers, everyone was doing something else. There was no signal to the crane operator. There was no hoisting. To this day, no one knows exactly why this load moved, but it shouldn't have.
You're going to minutes for rebuttal. Let's hear from respondent.
Thank you, Your Honor.
Respondent?
May it please the court, I'm Steve Arapach from O'Dwyer and Bernstein for plaintiff Shannon McGregor. Defendant's argument puts the cart before the horse. The fact of the matter is a bundle of steel I-beams weighing several thousand pounds was lifted 6 inches in the air because it was hoisted by a crane. Since it was hoisted by a crane, it is a hoisting procedure. And the labor law requires that during a hoisting procedure, even if it's a defective hoisting procedure, that the safety devices, securing devices be provided. The labor law does not say, if the crane is hoisting something, if everyone is ready, then you get safety devices. In this case, if they had...
Counsel, this is Judge Owing. It sounds like the argument you're making is, as Justice Moulton and Justice Singh have already made it for you, is like these taglines are there for a reason, or the use of a tagline is there for a reason. I mean, I heard the appellant's argument saying, whether you had the taglines or not, as you're saying, the minute it's hoisted, if nothing happens, you're all okay. But that's not the point. That's it. The taglines are there for what the requirement for taglines there is for a reason. Whether or not you need it or not, that's besides the point.
Thank you. So
I thought it'd be simpler. I think that's what you're trying to say. It doesn't really matter. You need the taglines.
yes, thank you. And by the same token, as this court held in Flores, the lack of taglines is also a clear violation of the industrial code provisions requiring taglines. And to the point of plaintiff's cross appeal, plaintiff was also entitled to summary judgment under Labor Law 241-6, predicated on the violation of 23-8.1 F2I, which prohibits sudden acceleration or deceleration of a hoisted load. It's uncontested that this load was suddenly jerked 6 inches into the air, and then they stopped raising it abruptly, so that the momentum caused the 3 I-beams to separate and come loose and splay out and hit plaintiff and knock him off the top of the truck. So, and defendant, the motion court incorrectly determined that there might be some emergency reason why the load was hoisted. But the only emergencies are those that the rule contemplates are to prevent a hoisted load from hitting someone. There's no emergency that requires a load to be jerked 6 inches into the air and then left there. And plaintiff testified the load should only have been hoisted if the foreman had signaled. And
Counselor, this is Judge Singh. How do you respond to your adversary's argument that, in fact, you haven't established causation in this case?
The causation actually seems obvious. As plaintiff stated in his affidavit, if taglines had been used, they would have secured the ends of the bundle. As it was, the bundle of steel was only in one single line in the center.
So is it your argument, counsel, that the lack of safety devices was the proximate cause of the accident? Is that what you're saying?
Yes.
Thank you.
Okay, great. You'll have a minute for rebuttal. Let's hear from appellant again.
Thank you, Judge Kern. Plaintiff, in fact, to be technical, it's the industrial code that requires the taglines. Labor Law 240 and Labor Law 241 don't specify taglines.
So counsel, your adversary's
violation. I'm sorry, Justice Singh?
Counsel, your adversary's point, I think, is that it was a lack of a safety device on these heavy beams that are being hoisted was a proximate cause of the accident. The beams shook, something happened, and he fell off the truck. Why isn't that a good argument?
Justice Singh, he still cannot explain how exactly in the 1 second bounce, counsel describes this in a very long drawn out way, but in fact, his client's testimony is this load bounced for just a second. Counsel cannot explain how in just a second, any workers, no matter how prepared they were, including the plaintiff, could have grabbed taglines and guided this load fast enough to prevent this accident from happening. Well, it's physically impossible, and that's why there cannot be any expert.
Counsel, do you have an expert saying that in fact it's physically impossible to secure this load? Is there anything in the record to support that argument you're making?
Your Honor, this court is entitled to look at the common sense realities of the workplace, and common sense being simply understanding that even in 1 second is not enough for a person to understand and react to any circumstance. That's a common sense reality that's within this court's purview.
Are there any more?
And by the
questions
way,
from the
plaintiff
justice?
has no expert either.
Are there any more questions from the justices? Okay, you have 1 minute for rebuttal.
Unless the court has any questions for me, I will rest.
Any questions?
Yeah.
Okay. The next case is Penna versus
Thank you.
Manhattan. Let's hear from appellant.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff, appellant, respondent. I'm going to deal with the 240 issue, both with respect to my respondent's claim and my appellant's claim. As you know from reading our briefs, we believe that the trial court got it 100% right when it granted summary judgment to plaintiff on the label law 240 subdivision 1 claim.
Mr. Isaacs, are there two versions of the accident? And if there are two versions of the accident, would your client be entitled to summary judgment under either version?
100%, Your Honor. And the case, well, very simple. I'm not even sure that there's two versions. If you actually look at my client's testimony at 451 and 450, what my client said was that he was within the double scaffold top level when the cable came down, about 400 feet of cable came down, struck his arm, and then he used his left hand to push that cable off him. So that may be what Mr. Riley was talking about, but it is 100% under my client's version.
Mr. Isaac, I'm sorry. I thought Mr. Riley said that the plaintiff actually reached out to grab the cable, and that was the account that he put into the safety reports after the accident.
Correct. And Judge Moulton, we know from the record that that would probably be impossible to the extent he went outside of where he was, because everybody, as far as I can see, who was present testified that that safety netting, that orange safety netting that was meshed, was not broken at all. There was no hole in it. Let's take what Mr. Riley said. Even assuming that that occurred, reaching out to stop a cable from falling on you is not a superseding cause of any event, especially under the Court of Appeals decision in Gordon, and many cases that cited to it. And your decisional law, as the trial court pointed out, citing to Ernish, but I think the best case is Orellano, and there's a case, John against Baharastani, which you're all very familiar with, says that you can have 1, 2, 3, 4, 5 different versions of the accident, but where the plaintiff's entitlement to judgment as a matter of the law is established, that the conflict in the evidence isn't material because the plaintiff is entitled to summary judgment under either of those versions. Here, no matter how you look at it, there's no question that this 500-foot-long, 300 to 400 pound cable was not secured. There was a prior incident, as the defendants admitted.
We take the point about that. Let's talk about the statutory agent argument with respect to Beach. Now, Beach obviously had no employees on the lift that day. It was being operated by Mr. Cummings of Jerome. So, how are they a statutory agent in this case? They created this lift. Let me ask you one question. How long was the lift in operation before the day of the accident?
I'm not sure the amount of time, but it was a fair amount of time. But that's not my point, Judge Moulton.
Well, let me ask you one other question, just following up on that. Were other trades besides the Glazers using the lift?
From what I can tell from this record, the Glazers were using this lift for the work that they were doing. But my claim is not that Beach was responsible for glazing work. I want to make that clear. If my brief said that,
clear in your brief.
I apologize. My claim is that this is not a glazing case. So let me just deal with your specific hypothetical, Judge Moulton. Let's say that there was a glazing accident. I can't tie Beach to that because Beach has nothing to do with it. But my claim is a scaffold claim. My claim is that the scaffold that Beach designed, that Beach manufactured, Beach was present, Beach inspected it, Beach was responsible for telling people.
This is Judge Kern. What about the fact that there were other entities at the site who had control over the scaffold? It wasn't just Beach, and that there's at least a disputed issue of fact as to who had ultimate control on the day of the accident as to giving permission as to who could use the scaffold and whether it was appropriate that day.
Correct. So what we cited to was specifically your decision in Tuchillo against Bovis. It's 101 AD 3D 625, and a case called Her against Baccarat 70 AD 3D 487. Which this court held that the fact that more than one entity has control over a site does not stop them from being.
But in Tuchillo, there was an actual written subcontract that Tuchillo, that the alleged third-party statutory agent, the alleged statutory agent had signed. So we knew the ambit of the responsibility of the subcontractor. Then they subcontracted, I believe, in Tuchillo. But in here, we don't have a clear contract. It seems that the parties agree that they had some kind of agreement, but we don't know. There's no written agreement defining the ambit of the responsibilities of Beach.
Well, if I may, Judge Moulton, and I know I'm going over my time, Judge Kern, if I have to, I'll take it off my reply. What I think Beach is saying is that the proposal and the subsequent change order wasn't signed. And that looks to be true. That's 2038 to 2040 of the record. But if you look at 2039 of the record, those terms were actually incorporated in the testimony. I don't think there's any question that if you read Beach's brief, they admit they were responsible for checking on the scaffold. They were responsible for determining whether it could be used. They were responsible for training the plaintiff and his employees as to the use of the scaffold.
Okay, sorry. I'll ask the question on rebuttal.
You have 2 minutes for rebuttal, so you can
Okay.
expand on that. That's fine. Why don't we hear from Mr. Safranek now?
Thank you, Your Honors. I represent the owners and the developers of the site, as well as the general contractor, who took their responsibility very seriously under 240 to the plaintiff and his co-workers, and so hired Beach to do everything with regard to this scaffold. Your Honor was just asking regarding what the ambit of the agreement was. The agreement says that the general contractor was to provide its own master rigger unless the master rigger was obtained from Beach, which is exactly what happened here. John Long was the master rigger that was obtained from Beach.
But counsel, let's talk about the proposal that Mr. Isaac was talking about a bit, because that also has some language on it on record 2040 that Beach was on the hook until turnover, which I don't know what the word turnover means. It's not a defined term, but it appears to mean turnover once it was given over to the trades to use to do the glazing on the building and whatever else it was used for.
And had the general contractor provided its own master rigger, that would have ended this discussion. However, that's instead of following the instruction on page 240 of the record, on page 239, it says, if you want us to provide a master rigger to maintain and train on this scaffolding, that'll cost you $7,500 a week, $1,500 a day. You had earlier asked, Your Honors had previously asked how long the scaffolding had been in effect. John Long, the master rigger employed by Beach, testified he was on the site over a year at that point. Over $400,000 spent by the owners to have Beach's presence at the site, training the workers how to use the scaffolding.
Mr. Safranek,
sure the scaffolding
did
was
other
proper
trades
condition.
use it as well? Did other trades use this mobile scaffold?
Yes. But every person who used the mobile scaffold had to be trained and approved by John Long. So while earlier in the project there had been demolition, they were changing the stone facing on the outside of that ugly Verizon building to have glass windows instead, down by the river. So they took off the stone panels earlier, then the glaziers went and they installed the windows, and then they were in the process of caulking the windows and doing final work on the windows when this accident happened. And I agree with Mr. Isaac. If a window had fallen out on the Jerome glaziers, that would not be a Beach issue. But Beach is the only one, as far as the record shows.
Counselor, is that correct? Didn't AIC, one of the GCs on the job, didn't they have responsibilities with respect to the scaffold?
Yes, and they satisfied their responsibilities by paying Beach Industries.
Their responsibility,
to provide the master rigger.
I'm sorry, their responsibility was just to pay and not to inspect the scaffold or do anything else with it?
Well, respectfully, Your Honor, the general contractor is not an expert in this kind of scaffolding. It's why my brief referred to the Izzard case, dealing with elevators, which is a much more close analog to this kind of scaffolding than Beach would lead the court to believe. This was not an ordinary kind of scaffolding that's piped together and anybody can operate. That's every worker that worked on that scaffold had to be trained by Mr. Long in order to be approved to use the scaffolding. Before the scaffolding could be used on any given day, Mr. Long had to approve of the conditions. He had to approve that the people were using it.
Mr. Long was not driving the scaffold after he trained them. And how long was the training? An hour or so, or was it longer than that?
That's The record is unclear as to exactly how long the training was, but he was there every day, all day.
But after that, Mr. Cummings was running the scaffold, right? I mean, Mr. Cummings of Jerome was running the scaffold, not
according to the instructions that he had received from Mr. Long. He wasn't. There's no question that they were following the instructions. Mr. Long said that there would be no problem. His testimony in the record was that it would not create a hazard if the cable were falling outside of the box. So if he instructed the workers that, and then it's the same cable that was falling outside of the box that struck Mr. Pena, that's given that that's Mr. Pena's testimony following the commencement of the lawsuit, then the only evidence in the record is that Beach was the only entity that was maintaining the scaffold and that ever touched that power cord.
Okay, you're going to have to rebuttal, so let's hear now from Mr. Fitzpatrick.
Good afternoon, Your Honors. It please the court. The lower court properly denied summary judgment to the plaintiff on his 241 claim as against Beach. Beach was not a statutory agent. There were questions of fact as to whether Beach retained.
Counselor, what other entities had responsibility with respect to the scaffold other than Beach?
Well, AIC, pursuant to the contract, was responsible for the equipment after it was installed. Moreover, site safety had trump authority over Mr. Long as to whether the scaffold could even be used. On the day of the incident, the testimony was that the ultimate green light had to come from Mr. Riley as to whether the rig could be put in.
But is that accurate? Isn't the testimony that your client said it was safe? Site safety could have overruled if it wanted to, but that didn't occur. Isn't that right? Isn't that what the testimony was?
Well, there's conflicting testimony, the question of fact, and the testimony was that Jerome, plaintiff's employer, was pushing for the rig to go out. Mr. Riley testified that the wind readings were taken by Beach, but that he ultimately decided whether it was safe for the rig to go out. And what is important to note is that the rig was under the exclusive control at the time of the incident by Jerome. Mr. Cummings was operating the rig.
But there's nothing to suggest that there's anything wrong with the rig. Isn't the issue whether or not the rig went up? That's really what we're discussing.
There is no evidence of anything wrong with the rig. It was approved by the city of New York, and it was inspected by the Department of Buildings immediately.
So the issue is, should Long have authorized or agreed that it was safe for it to go up? Isn't that the only issue? And isn't it your client who made that decision?
It was not entirely my client because the wind readings had to be taken. It could not be put into use if the wind readings were above 25 miles an hour. And ultimately, Mr. Riley was the one who had to give the green light. It wasn't sufficient simply for Mr. Long to say it was okay to put the rig into use. It had to be approved by site safety.
Well, one view of the evidence is that maybe there were two statutory agents here, no? Your client as well as site safety.
There's been no argument that site safety was a statutory agent. Beach could not have been a statutory agent. It's been pointed out that the work was entirely directed and controlled by Jerome, and the operation of the scaffold was not entirely under the control of Beach, nor did the contract call for Beach to have control entirely over the scaffold rig. They did not have authority to make a decision whether or not the rig could go out. In fact, Mr. Riley testified that he was the one who had stop work authority. If there was an unsafe condition on this job site, whether work could be done or not, that was up to Mr. Riley. Mr. Riley had that authority. He was the one who could say the rig could go out, the rig could not go out. So before any work could be done with respect to the rig, Riley had to give the green light. That was the testimony. Now, Mr. Riley provided conflicting testimony. That is why the court properly found there was a question of fact. However, there's no evidence whatsoever to suggest that there was anything wrong with the rig. Additionally, we argued that 240 can't be granted against Beach because there's no evidence clearly showing that the cable fell. I think that's been a misinterpretation of the facts that the cable fell. The court must understand that the basket spooling the cable was beneath the level of the plaintiff's feet. The plaintiff testified he was standing on the second level of the rig. the basket was on the outside on the lower level. The basket was below plaintiff's level where he was standing. Therefore, the cable falling out of the basket could not have impacted him. Additionally, the plaintiff testified that there was wind causing a flapping of the cable. There's no evidence which actually demonstrates that the cable fell onto the plaintiff. It's possible that the wind may have moved it laterally, if at all, coming into contact with the plaintiff. And the incident reports, as testified to by Mr. Riley, indicated that the plaintiff put his hand outside of the rig. If you believe plaintiff's testimony that he put his hand on top of the railing, he was specifically instructed by Mr. Riley not to do that. But for him doing that, his hand would not have come into contact with the cable.
Council, this is Judge Joy. Council, this is Judge Joy. I thought, I'm fine. No question.
Sure, because his time is up, but if you have a question.
Yeah, that's good. We're good.
Okay, so let's hear from Mr. Isaac.
Your Honors, with respect to my adversary's last point that the cable went up, first of all, it's physically impossible. It was according to Mr. Biancardi, the scaffold itself is about 2 feet from the top, and the plaintiff testified it fell 447 to 448.
Mr. Isaac, this is Judge Owing. So that, the cable came to a final resting place on the scaffold where it was being spooled up. But it's still elevated from the top down, right? I mean, it's like a pole, right? It's coming down.
100%, and that's what the plaintiff testified to. The reason there's no contrary testimonies, nobody controverted the plaintiff's testimony. It's 440.
And about the hand thing, I mean, it was almost I read somewhere where the record where, regardless of what you think, it was like an instant reaction that he put his hand out. It wasn't that he kept his hand there when he shouldn't have. It was almost of a reflexive reaction. That's what I got to the sense from
correct. The testimony from the people who were there is undisputed. They heard a metal clang. Cummings stopped the scaffold, began to go down, and then boom, the cable on top spooled down and struck the plaintiff. So this is not a conscious decision; it's a reactive decision, as you said. Judge Moulton, if I can, I know where you're going with respect to the record. I'd also ask you to look at 2045 of the record. That's the change order. It's number 1234. It says, quote, GBL rigging foreman for up to 40 additional shifts for daily inspections, code compliance. That's in addition to the $7,500 per week that Mr. Safranak was talking about. And one other point, there's a huge difference between training Mr. Cummings to move the scaffold up and down with a control device and now blaming the plaintiff and other glaziers for not knowing how to deal with a specially constructed scaffold that has a cable that's free-flowing, where everybody knows that if it doesn't go into the basket, it's going to fly around. I don't think those two are equation at all.
Thank you very much.
Thanks very much.
We'll hear now from Mr. Safranak. You have 2 minutes.
Thank you, Your Honors. The appeal in this case on behalf of my clients is from the inconsistency of the lower court's decision. Either we know that plaintiff was struck by the falling power cable, and that's what caused his injury, and he's entitled to summary judgment under Section 240. But if that's the case, then that power cable was in the control of Beach. They oversaw the operative part of the work. They oversaw who used and when the cable. They inspected to make sure that cable was in. There is no evidence in the record whatsoever that anybody other than Beach and Beach's rigging foreman ever touched the outside and the operative parts of this scaffolding. The workers were simply users. The means and methods used by those workers was determined by Beach with regard to how the scaffold went up and down. Beach is the one who trained them in the means and methods of that work. So for Beach to stand back and say, well, they were doing whatever they want. That's why this is more like the elevator cases than Beach wants this court to admit, because all of the workers were simply following those instructions. Beach was the eyes, the ears, and the judgment for the general contractor on this site. We relied on their expertise to tell us when it was safe, when it was inspected, who could use it, and when. That's all of those decisions were made by Beach on behalf of the general contractor and the owners. They were clearly our agent for those purposes.
Thank you very much. Thank you. Okay, we're now going to call the next case, Garda versus Sun Capital. And we'll hear from Sun Capital first.
Good afternoon, Your Honor. Matt
Thank you, Your
Solom.
Honor.
Sorry, Your Honor. Justice Kern. Matt Solom for Sun Capital. Just very briefly, would like to move for the pro hoc admission of my partner, Martin Roth, who was about to speak a moment ago.
The motion is made.
Great. Thank you, Your Honor.
Thank you, Your Honor. May it please the court, Martin Roth on behalf of the Sun Capital Defendants Appellants. After Garda failed to sign a deal to buy SOS during exclusivity, a competitor outbid Garda by tens of millions of dollars. Garda sued defendants claiming damages from the lost deal, but the parties' contracts forbid such a claim. Both the NDA and exclusivity agreement expressly disclaim any obligation to proceed with any transaction before final documents, which were never signed. And outside of a 28-day exclusivity period, which indisputably expired, both contracts allowed defendants to negotiate with other bidders and terminate negotiating with Garda. The lower court therefore erred as a matter of law by failing.
This is Judge Singh. Why isn't it a good argument that there was, based on the course of dealings of the parties, including the various agreements you've alluded to, that the defendants had a duty of good faith to negotiate?
Two reasons, Your Honor. The contracts disclaim such a duty. The preliminary agreement, the NDA that was entered in July 2019, both said in paragraph 9 that nothing during the negotiations would lead to any agreement in principle. And secondly, in paragraph 10, it let defendants have freedom and sole discretion to terminate negotiations with Garda at any time for any reason. In addition, the letter agreement entered into in September also said that the parties would not be bound absent a final agreement. Under the case law of this court, in the Amcan decision and in the Pullman Group decision, such a claim is manifestly contrary to the language of those agreements. So,
but the claim here, sir, is that your clients essentially strung the plaintiff along, never intending to negotiate with them, never intending to make the sale to them, and as a result, they incurred all these expenses. Isn't there a base? Wouldn't there be a basis for them to at least recover some of those expenses?
no, Your Honor. They could have asked for expense reimbursement, which is a common commercial term. There could have been a breakup fee. There are lots of deal protections that Garda could have sought.
How about based on an alleged breach of the confidentiality provisions of the agreements?
It's the same problem, Your Honor, because the two agreements very clearly say on their face that there was no binding obligation to transact. And in order to turn those provisions of the NDA into an expense reimbursement provision, for example, this court would effectively have to read into the contract provisions that aren't there and override the parties.
If there was, let's assume for purposes of my question that there was a breach of the confidentiality agreement. What do you suggest the damages would be for that breach of the confidentiality agreement, if not the cost and expenses of negotiation?
There could have been a claim pled for damages. For example, in normal confidentiality agreement cases, you see a competitor using confidential information to compete. That is not the claim pled. The problem Garda faces here—
Isn't the claim pled, I'm sorry, maybe I'm misunderstanding the claim. Isn't the claim that you used information you obtained from us confidentially to get a better deal from our competitor in terms of the price they were willing to pay for this company? So therefore you breached our obligation of confidentiality to us in order to get a better agreement from our competitor. What, if that's a valid claim, what would be the damages for that?
Well, first of all, Garda could have sought an injunction to stop the deal at the beginning, which they never did. There was an injunctive relief provision.
My question is, what would them, assuming they have pled that and that claim goes forward, why shouldn't they recover as a measure of damages the expenses they incurred in negotiating the agreement?
Because, Your Honor, they haven't connected the breaches to the expenses. All they say is there were breaches without saying what those were, and we suffered damages. But they don't tell you when the breaches occurred. For example, Garda spent a lot of money on their advisors to ramp up and negotiate the deal well before they alleged the breaches occurred. On this complaint, there's no causal connection.
Saying to you, or they're saying in their complaint, look, we negotiated, we had confidentiality agreements, our damages occurred because you ultimately got a better deal from our competitor using our confidential information. So why wouldn't that encompass the whole period of the negotiations?
Because, Your Honor, the way that these contracts are written, they cannot state a claim based on the failure to get the deal. The parties agreed multiple times there was no requirement that they transact. So to say,
I'm asking you about getting the deal. I'm asking you about the expenses they incurred in negotiating the deal.
the expenses they incurred in negotiating the deal are still tied back ultimately, as this is pled, to not getting the deal. What they say in their complaint is because we lost the deal, we wasted expenses. That again is linked back to the fact that they didn't transact. Had they gotten the deal, they obviously wouldn't claim the expenses. And to turn the confidentiality breach claim into effectively a claim for damages, whether they're lost profits or whether they're expense reimbursement based on not getting the deal, would override the parties' clear agreement. Garda was represented by sophisticated counsel. They're a sophisticated party. They could have put in an expense reimbursement provision. They could have negotiated for a termination right or a breakup fee. On this agreement and these two contracts as they're written, there's no ability for
Counsel,
them.
are you saying that then the confidentiality provisions are rights, but without any remedy if there is a breach of that right?
No, Your Honor. There could be a remedy if, for example, they had sought injunctive relief. That could have been
okay.
There could have been a damages remedy if they pled a different claim. What we're saying is the way they've pled this claim, the damages cannot work because they pled damages based on not accomplishing a deal. If there were other damages that they could plead and prove, we would be having a different conversation. But the contracts as written, the clear terms of those contracts say there was no duty to transact. And reimbursing Garda, even for its expenses, because a deal didn't happen, collapses back on those same provisions. Again, the letter agreement expressly said on its face that there were no agreements in principle until there were final documents.
Okay,
and so to allow...
Attorney for SOS, you'll have a minute for rebuttal at the end.
Okay, thank you, Your Honor.
Thank you, Your Honors. May it please the court, Rahul Mukhi from Cleary, Gottlieb, Steen, and Hamilton on behalf of SOS Ultimate Holding, defendant appellant. We join in the arguments of the Sun Capital appellants, and I also wanted to briefly address arguments specific to SOS. As the court is aware, SOS was the target of this potential transaction that was being negotiated by two...
Counselor, this is Judge Singh. Counselor, could you answer my colleague's question as to, with respect to breach of the confidentiality provisions? If there were a breach, what damages, if any, would plaintiff be entitled to recover?
Your Honor, I join the arguments of Mr. Roth. The way, if you look at paragraph 1 of this complaint, says nature of proceedings is we lost this deal and we're claiming breaches of confidentiality caused us to lose this deal. Well, that's exactly what the contract said Garda was not entitled to. And paragraph 9 of the confidentiality agreement in particular says nothing said during these negotiations shall be the basis for a agreement in principle. That's exactly
that maybe that goes to lost profits. I think that's a good argument, but I still don't see why the plaintiff would not be entitled to its out-of-pocket expenses if you breach the confidentiality provision. Otherwise, it's just an illusory provision from my perspective.
You know, I agree with Mr. Roth. Look, there are confidentiality agreements that are negotiated that have more teeth. Some have less. They were represented by sophisticated counsel. It does not have any liquidated damages clause. It does not have a breakup fee. And the way they pled this case, and it's paragraphs 1 and 54 of the complaint, is that but for the confidentiality agreements, they would have gotten this deal.
Okay, you're going to have a minute for rebuttal, so let's hear from Mr. Garvey now.
Thank
you. May it please the court, Michael Garvey on behalf of Respondent Garda USA. Justice Friedman's 23-page well-reasoned decision articulates why this complaint satisfies notice pleading standards. It pleads the existence of binding obligations, breaches of those obligations, and damages caused by those breaches. We respectfully submit that the lower court's decision on defendant's 3211 pleadings motion should be affirmed.
Counselor, can you address the questions we've been asking with respect to damages? What damages, now I'm discussing really the confidentiality provisions of the agreements, what damages, if any, do you believe that you're entitled to recover?
We plead and are entitled to, Your Honor, breach of contract damages, including reliance damages, which I think will go to the thrust of Your Honor's questions, the millions of dollars of expense that Garda incurred getting ready to sign this purchase agreement.
So with respect to the reliance damages, your adversaries contend that the way you've pled this complaint, you wouldn't be entitled to it. In essence, what you're looking for are your lost profits that you're not entitled to.
So, Your Honor, we very clearly plead both reliance damages and lost profits. Expectation damages are well pled in this complaint. And I want to underscore that because that's very important. We plead in no uncertain terms that had the leak of confidential information not occurred and been used by defendants to entice Allied into this transaction, defendants were ready to sign the purchase agreement with us. This is an extraordinary case, Your Honor. We had a final agreement. We were there at the altar ready to sign it, and we're told by defendants that they had
Counsel, aren't you going back to duty to negotiate now, though? We're talking right now about the damages for breach of the confidentiality agreement.
Your Honor,
was you claim for duty to negotiate in good faith.
Yeah, so Your Honor, I'm
How do you separate out those damages? What is the connection between the breach of the confidentiality provision and the reliance damages? How does one flow from the other? Which is, I think, what my Justice Singh just asked you.
So for both claims, both for our breach of confidentiality, the leaks by defendants of confidential information about the Garda negotiations to Allied, and for our claim that they breached the duty to negotiate in good faith, we seek both reliance damages, the amounts.
So I'm asking a very specific question, specifically with respect to the confidentiality. Let's say we do ultimately find that you don't have a breach of duty to negotiate, that you have not sufficiently pled that, and that what you're left with is a confidentiality claim. How does the breach of that confidentiality provision lead to the reliance damages you're seeking to recover, separate and apart from the lost profits damages?
Because as we allege it in our complaint, if the information had not been leaked in breach of the confidentiality agreement, this transaction would have been signed and finalized.
Counsel, that's not really at least the way I understood it, that's not really the breach of confidentiality claim. It's that if it hadn't been leaked, they wouldn't have got as much money from your competitor, not that you wouldn't have got the deal. I don't understand how they're leaking information about you stopped you from getting the deal. It just got them a better deal with a competitor.
So Your Honor, from Garda's perspective, right, it looked up at the altar and learned that its counterparty had leaked all this confidential information. Had that information not been leaked, this transaction would have been consummated, and all the expense that Garda incurred would have not.
See, but that, Counselor, that goes back to the breach of the failure of the defendants to negotiate in good faith. You know, and I at least speaking for myself, I'm not sure you're entitled to that claim based on the document. So what I'm really interested in is you responding to your adversary's arguments that the way that the confidentiality provisions were negotiated, you're essentially out of luck. You're not entitled to anything at this point. So that's what I want you to respond to.
And so, Your Honor, if that were true, then as you point out, the confidentiality agreements are illusory. The reason Garda insisted upon these confidentiality agreements was precisely to avoid the situation that defendants would leak this information to competitors.
So this is Judge Owing. I recall confidentiality agreements, and in those confidentiality agreements, there are provisions for damages, specific damages. And what comes to mind is my Martha Stewart case that I had to oversee. Mm-hmm. They had specific, detailed, injunctive release damages in terms of liquidated damages for breaches of the confidentiality agreement. I don't recall seeing those specifics in your in this confidentiality agreement, unless I overlooked it.
No, you're correct, Your Honor. This confidentiality agreement, and there's actually two of them, does not contain a liquidated damages provision or anything.
Yeah, so it was almost sort of like everybody's assuming to be on their best behavior, right? It's like everybody, which goes back then to your third cause of action, which is the good faith negotiations. It seems like all roads seem to lead back to your third cause of action.
So I don't know about that, Justice Owen, because I still say that the confidentiality agreements were very carefully negotiated by GARDA to ensure that defendants would not leak this confidential information.
Which is great, which is exactly to my point. If you were the ones who were drafting that, you would have put in so much teeth in those confidentiality agreements that they sneezed the wrong way, you would have gotten $1 million.
What we could have done, perhaps that's right. No one thought that this would happen. No one thought.
That's the issue that they're arguing. That's the issue that they're arguing, that the damages that you're seeking in this currently pleaded complaint is not sustainable. It's not. That's what unless I'm hearing it wrong, that's their argument. It's not like you're not entitled to damages. It's the damages that you're asking for.
So I would refer the court to this court's decision in RXR, which is what Justice Friedman cited below. That's a pleadings case. The plaintiff alleged a breach of a confidentiality agreement and alleged that as a result of the breach, it lost out on a future transaction. And this court held, reversing the lower court, that the claim, including the claim for expectation damages, survives a 3211 motion. We are going to show in this case that the purchase agreement would have gotten signed, but for the fact that defendants secretly leaked all of this information about the GARDA negotiation to Allied in an effort at the last minute to try to get a better deal. And had they not done that, defendants themselves admit that they would have gone through and done the deal with GARDA. So the breach of contract damages that we plead, and again, we're at the pleading stage, we have a lot of road to cover in this case. There's going to be discovery and there's going to be summary judgment motions. But what we plead at the pleading stage is that we suffered damages resulting from the leak of confidential information. And
thank you very much. Your time is up now. So we'll hear from Sun Capital. You have 1 minute.
Thank you, Your Honor. To quickly address lost profits damages, we've cited cases in the brief, the Goodstein case from the New York Court of Appeals, the Gorodensky case from the Southern District of New York, that expressly say those are inappropriate for a count-free good faith negotiation claim. With respect to the confidentiality brief claim, those run headlong into the provisions of the agreements. And the RXR case Mr. Garvey just cited was actually granted summary judgment based on the contract alone and affirmed on appeal. So whether they eventually lost on a motion to dismiss or won later doesn't make a difference. The Cornerstone case from the Northern District of New York we cited and the RXR later opinion all show that where you have clear agreements that there's no obligation to transact, you can't get expectation damages. On reliance damages, I think Justice Oing put it more eloquently than I could. All roads lead back to the good faith claim. There's no liquidated damages provision. There's no expense reimbursement. And Mr. Garvey couldn't give you an answer.
But then Counselor, if that's right, then confidentiality has just no legal effect. I mean, and that certainly can't be the law.
I disagree, Your Honor. I think that had they shown there was a breach that caused them damage, it absolutely would have affected.
Well, the claim is, as was pointed out by my colleague, is that you leaked confidential information to the competitor, and as a result, you sold the business for millions of dollars more than what GARDA was willing to pay for.
And on these documents, the way they're negotiated, it doesn't have effect to relieve them of those damages. They could have put in a breakup fee or a termination right and given it more teeth. They could have had some other collateral damage, like a harm to their business. They might be able to state a claim for that, but that's not what they've pled. On this complaint,
questions from the justices before we move on? Okay, so let's hear Sun Capital. You have 1 minute. Sorry, not Sun Capital, SOS. You have 1 minute.
Thank you, Your Honor. I'll spend my 1 minute on SOS-specific issues unless the court has any questions. With respect to the breach of contract claims, SOS has a separate argument that it is not even alleged specifically that SOS breached. Paragraph 51, which is the main breach of contract claim, does not even mention SOS. Paragraph 53 just groups defendants together in one sentence, and under the Court of Appeals decision, Aetna, that's not sufficient to state a claim under notice pleading. With respect to the good faith negotiation, again, SOS was the target here. Two other parties were negotiating over the sale of it. It was not doing any negotiating. There's two collateral discussions that are not negotiations of the deal alleged as throwaways in the complaint, but no allegation that SOS was negotiating. And then finally, there's no allegation that SOS made any promises with respect to the promissory estoppel claim. Frankly,
thank you very much.
Thank you.
The next case is People versus Delgado. Ms. Ratner.
Good afternoon, Your Honors. Jody Ratner on behalf of Appellant Jimmy Delgado. The prison sentence that was imposed and then reimposed on Jimmy is 4 years longer than the childhood he experienced on the outside before being incarcerated. Nothing can bring Londell Bird back, but is it too harsh to incarcerate a youth at 18 years old, one who had no prior felonies or violent tendencies, and keep him behind bars until he is 40 years old?
Has your client ever expressed remorse in this case?
Your Honor, it would be inappropriate for my client to confess because he still has available relief open to him. He has pursued a 440 on the grounds of ineffective assistance of counsel, and although this court denied leave to appeal that, he still could pursue a federal habeas corpus on those grounds. So although he has not confessed, he has—
No. It's not confession. Expressing remorse for his actions.
Well, if he admits it's his actions, then I believe that would be in confession, but he has expressed empathy for the family in this case. At the resentencing proceeding, he turned around and choked back tears and acknowledged the loss of the family, which is a sign of empathy, which was not displayed in some other cases in which this court has declined to reduce sentences in cases where it found that the defendant was callous. In this case, during this litigation, my client has never shown callousness or been dismissive of the loss that occurred in this case. So incarcerating him until he is 40 years old, which is 7 years beyond the minimum already being an exceedingly long sentence, where there is a possibility of rehabilitation. And that rehabilitation is in the record before this court. At the resentencing proceeding, we submitted evidence that Jimmy has done the hard work of learning nonviolent conflict resolution.
And how is your client I don't know, behaved while he's been incarcerated?
Of course, his record is not perfect, like most of the people who are incarcerated. It's an incredibly difficult situation. He's had some fighting. Those occurred in the very beginning of the time that he was incarcerated in prison and in docks when he was about 19 or 20 years old. Since then, the only incident of fighting, he was the one who ended up with injuries. It is unclear what happened.
You can have a minute for rebuttal. Let's hear from the people.
May it please the court, Noah Shamoy for the Bronx District Attorney's Office. Briefly, I intend to address defendant's argument that he raised for the first time in his reply brief that he's seeking a waiver of the mandatory surcharges. We don't consent to the waiver. This is not a direct appeal, unlike the cases he's relying upon, and the defendant's making no attempt, even in this reply, to meet the statutory requirements of it being an unreasonable hardship, an adverse impact on his reintegration, or otherwise that it is in the interest of justice. We didn't have a chance to reply. I just wanted to point that out. As for the sentence itself, this court perceived no basis to reduce the sentence on direct appeal, and defendant has identified no new facts that should change that determination. This was a premeditated and planned assassination, an act of revenge with no covering. He did it in front of the individual's friends on the very street of the victim's family, who had to walk outside to find him bleeding out on the street. Since his incarceration, it's not that he has not been a model prisoner. He's been involved in violent acts, drugs, and refusing to comply with orders, as we point out in footnote 5. Again, there's simply no reason to consider reducing the sentence now. Thank you.
Thank you. You have 1 minute.
Thank you. As to the fees, I would contend that this is a direct appeal. The sentence was vacated. It was reimposed. This is the direct appeal from that sentence. We had a right to.
What's a direct appeal? Why should we consider something raised for someone reply, which is not allowed under our rules?
That is true, but I do not see any policy or other reason to maintain the fees when the state's legislature has determined that fees are inappropriate for youth. We would just ask this court to consider who this 18-year-old man was and who he can become with continued work and education and rehabilitation. And this court should allow the parole board to determine whether he should be ready for release after serving 15 years. The parole board can always decline to release him. He has a life maximum, but he should get that opportunity to prove to the parole board that after 15 years of serving a sentence, when he is still going to be in his 30s, that he should get the opportunity to be released, to be a contributing member of society.
Thank you very much.
Thank you, Your Honors.
Okay, the next case is Avalon Automotive. We'll hear from Mr. Hecker.
Good afternoon, Your Honors. Sean Hecker for Plaintiff Appellants, Avalon Automotive Group, and Karan Abagumian. Your Honors, Justice Sherwood's decision below was plainly flawed. Were it allowed to stand, it would serve as a step-by-step blueprint for how to steal money from investors. But in rejecting each and every one of plaintiff's claims at the pleading stage, including those brought against a defendant who had not moved to dismiss, Justice Sherwood committed a number of plain legal errors, certain of which defendants concede on appeal, namely that a fiduciary duty is a required element of an unjust enrichment claim, and that an unjust enrichment claim only applies to a claim for failure to pay for services. But the record establishes that Justice Sherwood fundamentally misunderstood plaintiff's allegations and as a result erred in dismissing other claims as well. The facts alleged here, many of which appellees omit from their brief, are quite brazen. Defendant Sergei Leontiev induced my clients to lend tens of millions of dollars to companies he controls. He then used his control over those borrowing vehicles to secretly
Counselor, I think we're aware of the facts. Going back to your unjust enrichment claim, you asserted against all defendants. So let's use defendant like Wonderworks, for example. Did Wonderworks benefit from the alleged looting of the funds by Mr. Leontiev?
Wonderworks absolutely benefited from the funds that were looted. It allowed Wonderworks to make both to make investments and earn money to pay employees, including defendant Kolotnikov. So absolutely, it benefited from the funds that had been looted from the borrowing entities. The same is true ultimately for defendant Kolotnikov, who was paid salary out of funds, as alleged, out of funds that were looted from the borrowing vehicles. And while he was conspiring with defendant Leontiev to arrange to have the funds transferred out of Wonderworks and into an asset protective trust in an offshore jurisdiction where it couldn't be reached. So
how long were the monies? How long were the monies in with Wonderworks before they were transferred out?
Your Honor, I don't know that we're able to trace precisely when the funds that were looted were moved out of Wonderworks and into the Asset Protective Trust, although we have reason to believe, based on the well-pleaded allegations here, that it was around the time when the meeting in London occurred in August of 2015 and in the period thereafter, as Mr. Leontiev was stringing plaintiffs along in promising repayment and in fact paying back $17 million of the monies that he'd looted. It was during that time that we've alleged that the monies were moved out of Wonderworks from Leontiev's control there.
It wasn't just London. There was the Moscow meeting too that sort of precipitated. I mean, it was like, it was really, based on your pleadings here, there was clear sort of stringing along your clients. It was the first Moscow meeting that got everybody excited, and then there was the London meeting.
That's exactly right, Your Honor. That's exactly right. And unbeknownst to plaintiffs at the London meeting, in which Sergei Leontiev promised in no uncertain terms to be responsible for repaying the funds and agreed to a repayment term of 2 years, principal only, with a $25 million amount to be paid in the first quarter of that year, which he partially fulfilled in paying the 17 million. But it was,
I'm sorry, going back to the London meeting. So you argue that Leontiev agreed to pay the funds, but and the recordings, the transcripts of recordings. But did he agree in writing to do that at that time? Didn't he refuse, in fact, to put this in writing?
He wanted the lawyers to paper the contract that had been agreed to orally in the London meeting, and then reneged ultimately when efforts were made to push forward with having that agreement reduced to writing.
Wouldn't it be fair to say this was more of a non-binding proposal to repay, you know, that kind of thing, as opposed to an actual affirmative contract, an agreement to pay?
No, we've alleged the elements necessary to make out a binding agreement at the London meeting. Leontiev entered into a contract with a representative of both Avalon's president, and Avagumian, and where he specifically agreed to the terms of the repayment, the amount of the repayment, and then there was a discussion about getting it papered. But it's true that
there was an agreement. Wouldn't it be barred by the statute of frauds, because the statute of frauds requires a writing for that type of agreement to repay for the debt of another?
This was not an agreement to repay the debt of another. This was an agreement by Leontiev to repay the funds himself. And that
was an obligation.
Well, he took it on as his obligation, as he said multiple times during the London meeting, which was recorded and transcribed. So he made very
But to take on an obligation is to say that, okay, I'll pay the debt of another, isn't it? Isn't it just another way of saying it?
I think not, Your Honor. I think in this case, he took it on as his own obligation, not as the debt of another. And in this case, you know, we've made clear, we've cited the Chirella case, for example, that demonstrate that promises that constitute an independent obligation renders the statute of frauds inapplicable here. And interestingly, appellees try to have it both ways with respect to the London meeting. There are only really two possibilities. He agrees to be bound by that agreement, or he's lying to us to string us along. We don't know which one is true for sure. We pled both.
But I don't really understand that argument, because just sequentially what happens, meeting is in August in London. In November, he pays $17 million. So in terms of this idea of present intent really going to the fraud case, I don't see how you establish that based on the circumstances here. Payment is made, and then maybe after that he reneges and decides he's not going to make payment.
Well, one reading of it is that he agreed and in fact paid the 17 million, intending to pay it back, and then changed his mind. The other is that he was stringing us along while he was having the funds put into a place where we couldn't get at them, and he made the payment to buy more time. But look, that's quintessentially a fact question. Dismissing that claim and the pleadings with respect to his intent in the London meeting, respectfully, we would suggest that's error. That's exactly the kind of claim that requires discovery, the opportunity to depose him, to determine his intent and what he was doing at the same time that he was making those promises. So we would argue that claim ought to be part of discovery in this case as it moves forward.
We're talking the debt here. We're talking is upwards of $60 million, correct?
The math gets a little complicated once you reduce the 17 million with interest. It ends up in that neighborhood. I believe that's right, Your Honor.
Okay.
Okay. Why don't we hear from opposing counsel and have 2 minutes for about.
Thank you.
Thank you, Your Honors. Robert Weigel for defendant Sergei Leontiev. This is a case where there was a written loan agreement. They are trying to collect a defined term called the debt. They acknowledge that it was reduced in writing.
Counsel, this is Justice Moulton. I don't think the existence of those contracts is your strongest argument, because the complaint is replete with allegations that there's a separate theft apart from those contracts that Mr. Leontiev committed. So I don't see that the existence of contracts bars the unjust enrichment claim anyway.
With respect, Your Honor, they do not allege anywhere that with any specificity, any transfers from the borrowing entities to Mr. Leontiev. The fraudulent conveyance claim that they're asserting is based upon claims from transfers from Mr. Leontiev out of his own assets to the various other defendants.
I think Justice Moulton was talking about the unjust enrichment claim, which does involve those type of transfers that ultimately benefit Mr. Leontiev. So
there are two reasons that does not.
That a viable claim?
Yes, this was a negotiated transaction. They got a bank guarantee in most of these deals from Pro-Business Bank. They could have negotiated for a guarantee from my client.
You're going back into the contracts. The questions I think that we're trying to stir you to is why isn't there a claim for unjust enrichment? So, I understand you say we look at the contracts, but assuming that the allegation is that your client looted these monies, why isn't there an unjust enrichment claim based on the sums that he personally benefited from?
Well, unjust enrichment claim, and the Court of Appeals has made it clear, is not a catch-all phrase to just apply anytime somebody thinks that there is no other cause of action. They do not allege that at any point in time prior to 2015, and these loans were made in 2017, in 2011, and 2014 as to Mr. Avagumian, they don't allege that they ever spoke to or had any communication at all with my client, Mr. Leontiev. And the Court of Appeals in the Mandarin trading case and the Georgia Malone case, yes, Your Honor.
Don't they claim that he was the mastermind of all of these transfers and ultimately the monies were funneled directly to him and his family through these trusts?
He was the president of the bank at that point in time, and the bank continued for 8 years after the initial monies were lent. They could have negotiated for a guarantee. New York law is used all over the world for loan guarantee.
This is Judge Owing. This is Judge Owing. In negotiating for a guarantee, yeah, if they knew or it was disclosed to them who was involved in the transaction, the bank or the plaintiffs would have asked for a guarantee. But it sounds like your client was sort of not a known or disclosed participant in these kind of deals. So that how can you say that, well, they could have asked for a guarantee? Yeah, they should have, but only if they knew about your client's involvement. It came after the fact when the loans were cut and the monies got transferred that all of a sudden, wait a minute, these monies are gone now.
Your Honor, my client was the president of the bank. They don't contend that they did not know he was there. We dispute very vigorously this idea that
they should have got a guarantee from the president of the bank. That would be very extraordinary to ask in a loan situation for the president of a bank to give a guarantee. I've never heard of that.
Go ahead and ask Jamie Dimon for a guarantee. I don't know if he's going to give it to you.
There are loans all the time made in New York to special purpose entities or shell companies. And if you're going to take the position at any time that somebody takes money out of an entity, I mean, there are elements to a fraudulent conveyance claim.
I'm sorry, Counselor, I want you to focus on the unjust enrichment claim. That's what we're focused on.
Yes. And I'm saying that unjust enrichment does not apply here. This was a written contract. They are seeking not only the principal, but also.
I'm not sure I agree with you in a circumstance where a party can go allegedly loot the money and then say, there's a written contract, unjust enrichment doesn't lie. If your client benefited from those monies, and I don't know if he did, there's been no discovery, then why wouldn't there be an unjust enrichment claim?
Actually, there's been an enormous amount of discovery because this is the second time we've been here. We had a whole litigation in the federal.
I'm familiar with the case.
Yeah.
We were on prior panels.
I understand that. The rule is, and if you look at the Vitale case, there's a similar assertion in Vitale of this court, where the assertion is that owners diverted monies that could have otherwise gone to a retirement fund. And the case law has just been consistently clear that it has to be something different than what the contract is covering. They are not only seeking the principal that they lent, but they're seeking the contractual interest. They are seeking what they would be entitled to under the contract. And they're not entitled to do that on an unjust enrichment claim. They might have been able to, if they could have pled it, stated some other sort of claim, like, I don't know, conversion or fraudulent conveyance from Ambrica to my client, but they don't do that. They can't. Sorry, Your Honor.
We're not deciding now what the measure of damages or exactly what damages might or might not be recovered in an unjust claim, whether interest would be recovered. We're just trying to decide on a motion to dismiss whether it's pled. So to make an argument about whether or not they get interest in such a claim seems to be besides the point to some degree.
The only reason I'm making the interest point, Your Honor, is to make it clear that what they are seeking here is completely coterminous with what the contract is. In other words, this is not a situation where, like in Sergeant's Benevolent Association, where there was a fiduciary duty and that the court found that there was a unjust enrichment claim because that fiduciary duty had been breached. Here, there is a contract that can.
That's a quick question. You know, we're talking about the companies that actually were the borrowers for these funds. Unless the pleadings here indicate, at least allege, that these companies, the borrowers, became insolvent as a result of your client's acts or conduct. So that, you know, you keep going back to the fact that there's a contract here, there's a contract that the plaintiffs can sue on. Well, that may be accurate factually, but in terms of reality, they've got nobody. They're all, unless you're going to tell me they're not insolvent. The bank itself is insolvent too. The bank itself went under, so that they're basically held with the papers that they had their contract is on. It's not worth anything, and that's the result, at least allegedly, based on your client's acts or conduct.
Again, they do not plead with any specificity when my client supposedly took this money. But I will say that they asserted a claim against the bank in Russia. People lend money all the time that doesn't get paid back. Okay. This was a risky loan. They made it.
Thank you much, counsel. Your time is up now. Let's hear from Mr. Hecker.
Your Honors, I'll just emphasize 2 quick points. Number one, this court has repeatedly upheld unjust enrichment claims where the conduct complained of constitutes a diversion of funds that may have been the subject of a contract. So Sergeant Benevolent Association is a great example, and that case didn't rest on the existence of a fiduciary duty. Neither did Balance Return Funds versus Royal Bank of Canada. This is well-trod territory, and this court has repeatedly upheld unjust enrichment claims, particularly where the culpable party couldn't be pursued on the basis of a conventional contract or tort claim here because Leontiev wasn't a party to the contract at all. And the second point I'd make with respect to fraudulent conveyance claims, as Mr. Weigel knows, we in fact did assert fraudulent conveyance claims both with respect to the transfers out of the borrowing vehicles and the later transfer out of Wonderworks to the trust. So we have pled that claim as well. And okay. I'll otherwise rest on our papers. Thank you.
Thank you both very much. We'll now call People versus Carey.
Allison Kale on behalf of Mr. Hubert Carey. Mr. Carey was deprived of a fair trial at nearly every turn of this case. During jury selection, the court erroneously denied 3 for-cause challenges to prospective jurors. First, there was Thomas Fields, whose automatic disqualification was required pursuant to CPL.
Why automatic disqualification? Here's a man who's been a prosecutor, defense lawyer, and also a defendant. I couldn't think of a more ideal person to sit on a jury because he's seen it from every perspective.
Your Honor, it's because he has a current ongoing relationship with the prosecuting agency. This court's clear in Southall, and I'm quoting.
Hold on, counsel. You're talking about the seminars and the CLEs he does, right? Is that the relationship you're talking about?
First off, it's not clear that they're seminars or CLEs. They're called presentations, and it's trainings, and it's on jury selection that's occurring during Mr. Carey's trial. And he's speaking to the bureau chief of the trial district attorney about this
Was this brought
presentation.
before the judge, though, during the voir dire?
So it was not initially. Mr. Shields did not disclose it, and he didn't, as a criminal attorney, should have known that something like this should have been disclosed.
Correct me if I'm wrong, but didn't the prosecutor, before they went forward, consented to having him removed? And,
Yes.
and the defense counsel didn't accept that?
So before Mr. Shields was on a panel, when he was initially in the group, the prosecutor offered to dismiss him, but there was nothing about the facts about his relationship with the prosecuting agency that defense counsel knew at that time. Defense counsel had a right to hear him out to see if he was biased or if he had current relationships with the prosecuting agency. She didn't know any of that when the prosecutor offered to dismiss him. Once those facts came out, she sought to dismiss Mr. Shields for cause. And again, it wasn't Mr. Shields who disclosed those facts. It was the trial district attorney who had to disclose them. And the point here is that Mr. Shields, if he's on this jury, he creates an appearance of impropriety. It erodes the public's confidence to have someone who's on this jury who is working with the prosecuting agency, potentially at the time of Mr. Carey's trial, training prosecuting attorneys in that office. And Mr. Shields is asked, I mean, it's an implied bias case. I don't have to show actual bias, but he's asked, do you show this presentation to defense attorneys? I don't know. He's giving it to prosecuting attorneys. He's maintaining a relationship with a prosecuting agency because it benefits him and his practice and potentially his clients. It's a current relationship, and that's the line that's drawn in the cases. This court has drawn it in Southall, the 3rd Department, Druid, and Greenfield. That's what pushes this case over, and where Mr. Shields' automatic disqualification was clearly required. And even if it's not Mr. Shields, there are 2 other jurors here that don't give unequivocal assurances of impartiality that are directly related to their biases. You have Maya Halbert, whose disqualification was required, where she belatedly recognizes Mr. Carey and doesn't say, I'll be impartial and fair to him. And then you also have Leslie Paladin, who had concerns about how criminal complaints were handled, and there's simply no inquiry about those concerns at all. So she doesn't even have an opportunity to give an unequivocal assurance. And just quickly,
well, Ms. Halbert was, I'm sorry to interrupt you, counsel.
Oh, go ahead.
Ms. Halbert was questioned by the court, and she said something to the effect that I'm a designer, so I retain people's, I have a good recollection of people's faces. That's all she said. And she, yes. I think she said that she could be fair and impartial, and that's kind of the goal, what you have to say to stay on the jury.
Well, what she said was that she would evaluate the evidence. She didn't say, it wouldn't affect how she evaluates the evidence. She didn't say she would be impartial. That she would be
a juror, though, that they'll evaluate the evidence.
But she didn't. I'm sorry, Your Honor.
She doesn't know how she recognized him. She doesn't have any preconceived notion about him because she doesn't know how she even knows him.
There's a reason that she's mentioning this, and she's mentioning it belatedly, and it's not speculation to surmise that it's because she has a negative association with seeing someone who looks like Mr. Carey in the area that she sees him in. And then she also, it's confusing, the prosecutor asks a compound question where she gives an answer that implies she's not taking the presumption of innocence seriously either. And so there's no follow-up to that. And her assurance is not unequivocal at that point. And then just very quickly here, the sentence at the very least is clearly excessive. Anything above the minimum, where we're talking about less than $200 worth of shoes, where my client is the only one who's actually visibly injured in this encounter where the DA offered 5 years prior to trial.
I don't think that's fair to say about the injury. I mean, the security guard had her skin broken by his, he bit her. And that's, obviously people's mouths are very unsanitary, and she had to have a tetanus shot. And she said the pain was very bad. So I think that's an overstatement to say he was the only one who was physically harmed.
Sorry, Your Honor, I was qualifying that with visible injury because there was no photograph of that injury that was submitted at trial. My client had a photograph of a bloodied head that was submitted at trial. I apologize if that was stretching.
I may have misheard.
Okay, you'll have time for rebuttal. Let's hear from the people.
Good afternoon, it's Vincent Revelisi for the people. I think that if I were a defense attorney or a prosecutor, I might have exercised a peremptory challenge against a lawyer who had been on both sides, but I don't think he gave any reason to think that he would be unfair, and I don't think the relationship
what
that he
about
had,
the assertion,
giving occasional lectures.
Counsel, what about the assertion that he had an ongoing relationship with the prosecution?
I think that giving a lecture is something that all lawyers or senior lawyers often give lectures to either side, the defense bar, the prosecution bar,
But in
or
this
judges.
instance, is counsel correct that it was really with respect to the to the people's side that he was giving lectures? Was he doing it for the defense as well?
Well, he said he wasn't sure whether he had done it for the defense, and he only said he was giving one lecture to the people, but the prosecutor said that he had a, quote, relationship. And I think the word relationship is what got confusing here, but the cases don't say that any relationship is a problem. It says that a relationship of such nature that it would imply a bias is a problem. Here, where he has been a prosecutor, he has been a defense attorney and is currently a defense attorney and has been friends with people from all walks of the
And also,
prosecution.
also, and this is Judge Owen, and also, didn't he himself was caught up in, he got himself arrested, that this prospective juror got arrested, and he was fighting that, saying that the police officers were lying before the Queen's DA?
No,
I mean,
it was a different case where he informed the Queen's DA about a case where the police were lying and they dismissed that case, but that wasn't his own case.
Okay.
He was also arrested in his own case, so he has been in every role.
It sounds like he's straddling the fence on both sides. I mean, he had like experiences on both sides. I mean, it wasn't just.
I could see either side dismissing him for a peremptory challenge for their own strategic reasons. I just don't think he gave any reason to say he couldn't be fair or to imply that he would be biased for one side or the other. So I don't think the judge was wrong to say, well, I'm not going to excuse him for cause if the parties agree, which the prosecutor had originally agreed he would dismiss by consent. But when the defense attorney asked that he still be questioned and be part of the panel where there had to be a finding as cause or peremptory challenge, it came through that he should not be excused for cause, and it was just a legal ruling, and it was correct. So she used a peremptory challenge, and he was removed. And I think that was the right result in this case.
Can you talk about the sentence, counsel?
Yes. Well, it was only 1 year more than the minimum, and he had about 50 prior convictions and a couple of felonies. So it seems like that's not an abuse of discretion. It's not $200 is not that much to steal, but it wasn't just this case. It was also his criminal record. I don't think that was a wrong sentence. Any sentence in the lower range would have been fair. And I'll rest on the brief for the remainder. Thank you, Your Honors.
Thank you. You have 2 minutes for rebuttal.
Just very quickly, it's the current and ongoing relationship and the nature of that relationship. He's doing this presentation potentially during Mr. Carey's trial. That's not appropriate to have someone who is training prosecutors on a jury deciding a case. That's just inappropriate under the case law, and it shouldn't have happened here. It should have been an excluded juror automatically. And then we don't need to show abuse of discretion for a sentence reduction. That's very clear in the case law. Again, the district attorney offered 5 years and would have gone as low as 3. The minimum was absolutely the only sentence that was necessary here. Thank you.
Thank you very much. The next case is Hyatt versus Queens West.
Good afternoon, Your Honor. Jonathan Schaub for the defendant's appellants. The Supreme Court's order should be reversed because the record is replete with material issues of disputed fact. First, under the Court of Appeals decision in Salazar, there's a disputed issue of fact as to whether the provision of a safety device would have proved contrary to the work at hand. Here, there's no dispute that plaintiff was disassembling a tower that had been used to support a floor.
Counselor, is that accurate? Is that characterization of the record accurate? Isn't it more accurate to say that he was doing the dismantling in stages, and at the time when the accident occurred, when the scaffold collapsed, he wasn't working on the device that collapsed, correct?
So, Justice Singh, I'm glad you brought that up because that is, in fact, a disputed issue of fact. The plaintiff testified that he had stepped away in his deposition testimony, and the court had credited that. But there are also 3 incident reports that were prepared contemporaneously with the accident that indicate that at the time of the accident, he was actually dismantling the scaffolding.
Did you raise this below, or are you raising this argument for the first time on appeal, which would
This issue is being addressed on appeal, but
why, since it's a factual issue you're trying to raise and not just a legal issue on the record, aren't we prohibited from considering this for the first time on appeal but was not raised below?
It's a question in the sense, it's a legal question in the sense as to whether plaintiff carried his evidentiary burden of establishing summary judgment.
Actual question as to what you're now arguing a new fact for the first time, that he wasn't dismantling the other scaffold at the time, that he was dismantling the scaffold he was working on. That's clearly a new factual allegation being raised for the first time in appeal, which our cases are very clear is not permissible. So Why should
I appreciate what you're saying, but it was also these 3 incident reports were quoted verbatim in plaintiff's moving papers. So this is not a new fact that was completely dehorsed the record. It was in fact quoted and cited in plaintiff's motion for summary judgment, attached as exhibits to their motion for summary judgment. But I take the court's point. I'm not sure that it is under the court's jurisprudence and under the Court of Appeals jurisprudence. The key to determining whether Salazar applies is whether the object that fell was the target of the demolition. And this court has addressed that issue with 3 of the justices on this panel in Leveron, and Justices Oing, Singh, and Moulton were on that case, and in Raghuveer. And here, there's no question that the item that fell, or the tower that fell, was the target of the demolition, even if we credit plaintiff's deposition testimony, notwithstanding the reports to the contrary. There's no question that that was what he was setting up to demolish. So therefore, the Salazar doctrine would apply in this case. So moving beyond the Salazar issue, there's also an issue of fact as to whether the tower presented a foreseeable gravity-related risk at the time of the accident. The Supreme Court glossed over the foreseeability issue and said that foreseeability is not an element of a Labor Law 240 claim, but that's plainly incorrect under this court's decision.
So in this case, is this a falling object case?
Yes, this is a falling object.
It's a falling object case. Why are we getting into issues with respect to foreseeability? If this case is similar to Leveron, which my colleague and I sat on, wouldn't we analyze it based on that precedent? And that's the end of it.
So this is a falling object case because it was pled by plaintiff as a falling object case. And then the question becomes, this was an object that plaintiff pled and alleged required securing for the purposes of the undertaking. How do we determine an object required securing for the purposes of the undertaking? That is a question of foreseeability. Otherwise, every single object that falls in a construction site triggers Labor Law 240, which is exactly contrary to the Court of Appeals teaching in Narducci and Fabrizi. So that's why foreseeability plays into this case. And to paint the picture around foreseeability, plaintiff does not dispute that there was no issue with this tower prior to the time it collapsed. Plaintiff does not dispute that this tower was resting on a flat concrete surface. Plaintiff doesn't dispute that the tower had its 4 feet that were used for support affixed to it at the time of the accident. Plaintiff doesn't dispute that there was no defect.
Isn't the issue very simple? Is the statute applicable? Was the statute violated? Isn't that what we're focusing on? And isn't that what we should focus on?
But to determine whether the statute was violated, the question is, did it present a foreseeable gravity-related risk at the time of the accident? And in light of the work that was being performed.
This is Judge Owen, counsel, but that's like now changing. The way I understood the 240 context is we always talked about proximate cause. Now you're arguing that our precedent is saying that we should inject foreseeability into the 240 context. Doesn't that change the whole makeup of 240 from strict liability to just negligence now? Because foreseeability, in my understanding, is a negligence concept, not a strict liability concept.
So this court embraced the foreseeability concept in the Jordan decision, 1, and 2, the foreseeability factors in this case, because the labor law is violated when an object is being hoisted or secured or required securing for the purposes of the undertaking. There is no way to ascertain whether something required securing for the purposes of the undertaking. And this is.
No, but if you break down those facts, I looked at those cases. If you break down the facts and you peel them back, there are little wrinkles in the facts there, in the sense that in the facts that the injuries that occurred, or how the plaintiff sustained the injury wasn't directly a 240 situation, but it was sort of it flowed from a 240. In other words, for example, in a falling object case, the object falls down, hits a plank, the plank splins up, hits another plank, and then injures the plaintiff. There you can say it goes down the road from 240, as like Justice Singh said, it's no longer a 240, it's no longer restricted to a 240 analysis, but something else because of how the accident happened or what caused the accident. In this case, it's not like that.
So to take the Jordan case as an example, that's a case where a cable hit a rail and the rail fell over and hit him. That's no different here than this tap. Basically, if you find 240 in this case, every time an object falls at a construction site, it has to be a 240 violation, regardless of what it is. This was
or conversely, we find you. Go ahead. I'm sorry.
No, our time is up, but go ahead and ask the question. Go ahead.
No.
And then just briefly,
No, I don't want to give any more argument. There's another question.
I've withdrawn.
This is rebuttal time too.
I've withdrawn the question.
Okay, let's hear from opposing counsel then.
Good afternoon, Your Honors. May it please the court, my name is David Perisman, and I represent the plaintiff respondent, rather. Sorry about that. I think the court has already made all the arguments that I was going to make, but foreseeability is not an element. It was not inconsistent with the work. Their argument about the inconsistent statements, first of all, they're not inconsistent. And second of all, it's a brand new factual argument that they cannot make. They didn't speak of it in the papers below. So
going back to the foreseeability argument, why is not, in this context, why is foreseeability not an issue in this case?
I think the lower court said it well, because they said foreseeability only applies in permanent structure collapse cases, number one. Number two, it's never been an element, as Justice Singh said, in a labor law 240 case. It never will be, hopefully. And as the lower court said, it's not inconsistent. And also, as the court said, it is inherent in the work being performed. Scaffolds fall, ladders fall. This scaffold fell. If in this case, my client was required to prove foreseeability that scaffold can fall, well, then foreseeability would be read into every labor law.
Mr. Perisman, this is Judge Owing. So in this case here, the scaffold itself struck the plaintiff, regardless of what he's done. I mean, it hit him, right? It's not like the scaffold fell and then hit a storage bin that then fell on your client. No, you would have to argue, you would have to agree that in that kind of scenario, there may be a foreseeability argument. But when the scaffold itself, the instrument itself hits the plaintiff, there ain't no foreseeability there.
I agree with you 100%. It is not a Paul's graph case, or as Professor Crayer taught it in torts, the cat in the cue ball where the cat jumped.
Well, the thing is,
hit a cue ball.
I think Justice Singh kind of alluded to this, because if you inject foreseeability in the 240, it's no longer 240.
Correct. It would destroy the entire statute. And the court said it very simply. It's inherent. Scaffolds fall. Scaffolds are not supposed to fall down. They're supposed to be braced and secured so that they don't fall down. And this particular scaffold, a few minutes before the accident happened, my client was standing on it. He was using an intermediate platform so that he could reach the platforms above. The only thing that's different in this case is that he wasn't standing on it at the time it fell on him. He was standing beneath it. But there are multiple cases, Thompson, Salvagno, McAllister, just to name a few. We named them in our brief, all of which were scaffold or scaffold-type devices. If this court follows the precedent that you laid out in Leveron, you have to find that and affirm the lower court's decision here.
Thank you very much. You have 2 minutes in rebuttal.
Thank you, Your Honor. Just briefly, this was not a scaffold that was being used as a scaffold and as an elevated work platform at the time of the accident. It's the same as any other inanimate object at a construction site. And that presents the question, to go back to the foreseeability issue of how do you know that an object requires securing for the purposes of the undertaking?
But essentially, your argument will overrule the Leveron line of cases. I mean, that's what you're asking us to do in this case.
So, but then if we're going to go back to the Leveron line of cases, there is a question of fact. In Leveron, the roof that fell or the structure that fell on top of the plaintiff was not the target of the demolition. Right. Here, there is no question that the target.
But going back to how we started the argument, as was pointed out by Justice Kern, this is an argument being raised for the first time on appeal.
Actually, the Salazar argument is not being raised for the first time on appeal. The inconsistency between the testimony and the incident report was raised for the first time in this brief. However, this question of whether it was the target of the demolition, there's no moment-for-moment granular analysis that says, look at exactly what they were doing at the moment of the accident. That's contradictory to the Court of Appeals decision in Pratt's. And just briefly, there's one other disputed issue of fact in this case, and that's whether there was a device of the type enumerated in the statute that would have even prevented this accident. And that's along the lines of
Now,
Justice.
Was that, I'm sorry.
Argue that below?
What?
Did you argue that below?
No, but that is a purely legal issue because that is something that plaintiff had to establish to bear his prima facie burden. And in line with the Palermo decision, that
Safety device was required.
I'm sorry, what was that?
That is actual question whether or not the safety device was required.
He was required to establish that one was available, and he didn't plead that or identify that in his papers. That is a burden. That is his burden. That is a purely legal issue. And under Justice Oyen's decision in Palermo, when there is a question as to whether a safety device of the kind enumerated in the statute would have prevented the accident.
Does any justices have any more questions before we finish this argument up? Okay, thank you very much.
Thank you very much.
Thank you, Your Honor.
Okay. The next case is Jones. We'll hear from Appellate.
Yes, may it please the court. My name is Stuart Carlin. I'm representing the appellate Jerry Jones in this case, who applied for the position of a signal maintainer and was rejected because of a prior criminal conviction. If you, this is proceeding under, at least this part of the case, it's proceeding under the New York City human rights law, which I'm sure the court is aware has a liberal interpretation.
But counsel, this is Justice Moulton, didn't the agency weigh all the factors it was supposed to weigh under Correction Law 753 sub 1? And if that's the case, we have to give them some discretion in making the decision.
Yes, but again, what they did is did it in a very rote manner. If you look at you just look at the letter, they just cited one issue. The actual final determination said it was a risk to public safety. And
Counsel, this is Judge Owen, but your client was convicted of a gun possession, correct?
He was convicted of not registering a gun, which is an E-class felony. And he,
so wait a minute. So you're telling me that his gun was registered and then it became unregistered?
No, he was convicted of not have. He had it unregistered.
He had an unlicensed gun. He
Yes.
never had it. He never had it registered.
Correct.
Okay.
Correct. Okay. So he applied for the position of signal maintainer, and if you look at the factors that normally apply in this case under Section 72, first of all, the statute itself has a public policy to encourage the licensure in public of persons previously convicted of one or more crimes.
But counsel, can't the agency look at the underlying conviction? It involves a gun, which they believe is an unreasonable risk to the public and to employees of the agency.
But he, you know, there has to be a light at the rehabilitation tunnel. Okay.
Hold that point. Just on that point that you just made about light, a reasonable light, or in terms of the tunnel, he applied for the job right when he got out of jail, correct?
He applied for the job when he, well, yes, he tried to get reinstated. He tried to get reinstated first. That didn't work. Right. And then he was told to apply, and ultimately he was denied about 4 or 5 minutes, 4 or 5 minutes after that.
In terms of time lapse, it wasn't as if he had not been working for 10 years for the MTA and then decided now that he wanted to apply. And you know what I'm saying? It was sort of a very short time period. It was as if he got out and he applied it again. So that actually weighed into the administrative decision about how not enough time has passed for them to make that determination.
That is correct, but that's only one of the factors, and we can see that point in the brief, that factor does point in the direction. However, he's done, first of all, he got convicted and continued to work for 3 months without incident. So that sort of undercuts their whole entire argument that this exemplary employee who's been working for 9 years without any incidents whatsoever was continued to work after he pled guilty from February to sometime in May of 2018. So obviously they didn't reassign him. They kept him in that particular position. If you go through the factors, obviously the public policy is one factor. His duties are, he's a signal maintainer. He goes into the tunnel and fixes signals. He goes on the road. He does have some minimal public contact, but I would respectfully submit every single job that I could possibly think of, McDonald's, Burger King, auto mechanic. You can go down the list. Every single job has at least some minimal public contact, period. He can even work remotely because according to them, he would have to be under direct supervision. Okay, so he's basically, by not allowing him this job, they're basically undercutting a whole policy in this particular case of what criminal conviction law stands for. If you go to the third, there is no direct relationship between his conviction, which was nonviolent. It wasn't in the commission of a crime. It was wrong. He was remorseful. He served his time. He did what he was supposed to do. He submitted recommendations in from his new employer who had contact. Con Edison, basically through a third party, hired him.
Okay, counsel, you're going to have a minute for rebuttal, so let's hear from opposing counsel.
Thank you, judges. My name is Daniel Chu, and I represent the respondent, New York City Transit Authority. And if I could, I would like to go to the timeline of what happened here. The petitioner was convicted of a crime of illegal possession of a firearm, a felony, on May 2nd, 2018, and sentenced to 1 year in prison. He was released after 8 months, January 2nd, 2019, and on January 3rd, 2019 is when he reapplied for employment with New York City Transit. That amount of time, it was simply, there was no confidence on New York City Transit's part that, based on the seriousness of his offense, illegal possession of a firearm.
But is that, counsel, is that a factor under the corrections law that comes into play in determining whether or not to hire back the employee?
Well, it factors into the reasonable risk, but there cannot be an unreasonable risk to the public, to other workers, and that's where it plays in. Possession of an illegal firearm. A firearm is, it's a deadly weapon. And
well, you know, the firearm, we do have a gun epidemic going on in this town. You can't, I mean, this has happened in 2019, correct? This decision. So this has got to be weighing into the agency's determination, factoring into all these accounts at the end of the day. And it's based, this got referred to us as original thing, as original proceeding. So it's a substantial evidence issue that we have to look at, correct? Or is it arbitrary and capricious? No,
arbitrary and capricious, Your Honor.
I'm sorry, arbitrary and capricious, right?
Correct. Yes, Your Honor. Absolutely. I mean, a firearm, yes, with the gun epidemic, everything. That is something that New York City Transit takes very seriously.
And the short period of time from when he applied. This is not like 5 years down the road. You know, he's had a very good employment history, you know, and all that sort. This was like right the very next day. I mean, I gave him the benefit of the doubt. So shortly thereafter, you nailed it on the head when you say, no, it's the very next day that he applied.
Correct, Your Honor. Correct, Your Honor. And if I could go, I mean, to Mr. Carlin's point about the light at the end of the tunnel. I mean, there is a light at the end of the tunnel. I mean, this is not something, this decision, it's not an absolute bar on his employment. It's simply, yes, there was just not enough time to give New York City Transit enough confidence that he can work for New York City Transit where no one in the public is going to be endangered, his coworkers are going to be endangered, customers riding the train are going to be endangered, because this is someone who there is going to be contact with the public. He's a signal maintainer, and yes, they work in tunnels, but when they go into the tunnel, they all need to stage on platforms. When they're on the platform, they will come into the contact with the public. When they need to travel to different locations, they are on the train. When they come back from the tunnel, they come back together as a group and will encounter the public. When they break for lunch. So there will be contact with the public, and New York City Transit does not want to see anyone be injured. And one other point I would like to make is the petitioner raised that he had been working for a subcontractor. That was raised in his reply papers in response to on the original proceeding. He had indicated that he had just started working for that subcontractor in December of 2019. None of that evidence was before New York City Transit at the time that it made its decision. New York City Transit made its decision about 6 months earlier. So that did not exist, and none of that should be taken into account. Or in other words, New York City Transit decision should not be judged based on events that occurred after New York City Transit made its decision. Now, unless there are any other questions, New York City Transit would like to rest on its papers.
Thank you very much. We have you have 1 minute for rebuttal.
Yes, the timeline, he did initially put his reapplication in. That was rejected sometime in February, I believe, and I could be wrong on the exact date. He did actually apply, went through the entire process. The final decision wasn't made until May. During that period of time, he submitted in a letter from his current employer, which states Mr. Jones had worked for the VP Sprinklers. He obviously has contact with the public. Jerry's in good standing, ready to work hard every day, yada, yada, yada. He submitted letters in from the clergy. While he was in Rikers, he was in a training program. There's certifications that he was cooperating and doing everything that he could possibly do, okay? If the decision is denied here, he's consigned to public assistance. Let's just call it the way it is. Because there isn't a job that doesn't have that doesn't have some contact with the public. He's not interacting with the public. He's just heard respondents' counsel. Yeah, he's getting on the train. He's walking on the platform. If he can't do this manual position, which really has no practical contact with the public, then there's truly no position he would qualify for.
Thank you very much.
All right.
Okay. We are now calling the last cases. Upon further reflection, I don't think they really need to be argued separately, Ryan and Clear Channel. I think they can be heard together because they're overlapping arguments in the same council. So I'm going to give each side 7 minutes to argue both the cases. So you should address all arguments in Ryan Lee Properties and Clear Channel. Okay? Okay. Go ahead.
Yes, good afternoon, Your Honors. For the petitioner, Patrick Hilduff, Charter, Krinsky, and Drogan. Your Honor, these are transferred Article 78 proceedings. We submit that there is no deference warranted regarding the erroneous Oath Appeals Board decision upholding DOB's position with respect to the non-conforming use status of the advertising signage at issue. We believe this is an issue of statutory interpretation, specifically those provisions of the zoning resolution that govern that.
I'm sorry, counsel, weren't there factual findings, for example, with respect to the non-conforming use made in this case?
Your Honor, the ultimate determination was that we did not establish non-conforming use below. But again, we believe that this is an issue of statutory interpretation. So were the court to apply the standards in the zoning resolution with respect to non-conforming use status, the discontinuance of that use, and specifically the provisions 5283 and 5261, that we indeed did establish non-conforming use status.
Counsel, I can think of at least two fact issues. I'm sorry to interrupt you, but the 1979 permit only dealt with a single-sided sign. That's one fact issue. And another fact issue is, I think it was the plaintiff's burden, and correct me if I'm wrong, to show that there was no gap of use for 2 years in any of the relevant period. So those are fact issues that led to the findings, that, as I understand it, of oath.
Your Honor,
Counsel, then Judge Owing, this is Judge Owing. There's an additional thing that I wanted to tack onto Justice Moulton's points, is that the within 200 feet from an artery, from an arterial roadway, in terms of these signs.
Yes, Your Honor. The provision, first of all, with regard to the arterial highway, those summonses were dismissed below. So those particular summonses are not before the court on these proceedings. The summonses in each of the proceedings that were sustained that are before the court on the Article 78 are the charges alleging that the signage violated 3263 of the zoning resolution, which is a provision that says that advertising signs are not permitted in certain commercial districts. Because this premises is in a special mixed-use district, it was zoned C61.
So counsel, I'm sorry. So how have you shown here that the non-conforming use went on without gaps. It was exceeding the 2-year period.
Yes, Your Honor. We had first the establishment of the non-conforming use from the 1979 legalization permit.
And so let me stop you there for a second. As was alluded by my colleague, 1979 permit was for one single roof sign, correct?
Your Honor, no. We believe that permit did authorize the double-sided signage that was displayed at the premises, and that was also confirmed in the affidavit of Mr. Thuryoung, who was not only the owner of the property at the time, but also the principal of the company that operated the outdoor advertising sign.
So I understand what you're saying, but it sounds like that there were factual determinations being made by the ALJ, for example, whether or not or how much weight to give to Mr. Thuryoung's affidavit.
But again, Your Honor, this all ties into the issue of whether or not there is a demonstrated non-conforming use, and we believe that's an issue of statutory interpretation where no deference is due. No deference is due where, you specifically have a statute, and there's a question of the application of that statute to the particular facts at hand. And we believe that we had demonstrated in the tribunal below that the signage was in fact in compliance with 5283 of the zoning resolution and 5261. There had been a use that was established that was reflected by the 1979 permit.
So you're saying that, I'm sorry, you're saying that the 1979 permit permitted a double sign?
Yes, Your Honor. We believe that permit did authorize the double-sided signage that was
and that's
in place
based on the affidavit?
Specifically, Your Honor, two things. Not only the affidavit of Mr. Thuryoung that this was the permit that was obtained at that time, but also including the reference to the sketch itself does depict two intersecting lines, and we believe that was meant to depict a double-sided sign at the premises. But again, Mr. Thuryoung specifically recounted that this was the legalization.
Okay, I understand he says that. I read his affidavit, but other than his affidavit, what was the evidentiary basis for the statements he made in his affidavit?
Because Mr. Thuryoung was the principal who had not only owned the property but had operated the signage at that time. He had unique familiarity with respect. He was long since he sold the property in 2004 to the current owner, the named respondent Ryan Lee Properties. But Mr. Thuryoung was also an outdoor advertising company operator in addition to the owner of the property. It was his business to own and to operate and to market that sign to others for outdoor advertising purposes. So he had a unique perspective with respect to the operation of that sign. And we believe when you look at not only Mr. Thuryoung's affidavit, but also the other documents that were submitted and the arguments that were made to oath below, including the depiction of the 1980s tax photograph, the 1997 lease between National Land and Building and Universal Outdoor, and then ultimately the 2009 permits that were issued.
Counsel, this is Judge Owing. I got a simple question. If this is a straight up statutory interpretation of non-conforming use, why do we got to rely on affidavits? I mean, I could just look at the permit itself, and I don't even look at an affidavit. If the permit says you're allowed to have double-sided, postings or advertising, that's the end of it. So why do you even need the fact that you have to get into affidavits and have them explain the permit leads me to believe that the permit's not clear. So that it comes down to an ALJ's determination of actually how they're reading that permit.
Your Honor, the purpose also of the Thuryoung affidavit was also as part of demonstrating the continuity of the use to supplement the other documents.
You just skipped over exactly what I just asked you. We're going back to Justice Singh's comment about does the permit allow single side or double side? And you said no, it allows double side, and you're relying on the affidavit to make that point. And my position is, borrowing your argument about how this is a straight up statutory interpretation and they got it wrong, you're absolutely right. It's a straight up interpretation. So why do we need an affidavit? I could look at the permit and decide, right, whether or not it's double sided or single sided. But the fact that you're relying on an affidavit to demonstrate that it's double sided leads me to believe that it's not, that permit's not clear.
Your Honor, again, the affidavit was offered to give as much of a complete picture as possible in terms of.
That's what I'm saying. I don't need a complete picture. If it's statutory interpretation, we're empowered to read the statute and say, you know what, it's A or B. I don't need someone to tell me, well, you're telling me the affidavit is there to explain to me what the permit means, which then ropes in the agency's power or authority to decide whether or not they agree or disagree with your interpretation of the permit.
But Your Honor,
I could be reading
but Your
this
Honor,
wrong.
it's that. But Your Honor, it's that again. We do believe that the way in which the sketch is depicted on the permit document shows the two intersecting lines. We believe that does show that in fact this did authorize a double-sided sign. But
Would you concede,
again, I think
would you
this comes
concede,
back
counsel,
to
that it's subject to interpretation?
Your Honor, we believe that the permit authorizes the double-sided signage. And again, we only offered the Thur-Young affidavit just to provide some additional context. But again, we believe the permit document does authorize that. But even if it were to be the case,
any further questions from the justices on this matter? Okay, let's hear from opposing counsel.
Good afternoon, Your Honors. May it please the court. My name is Elizabeth Friedman, and I am appearing for the respondents. Your Honors, substantial evidence does support the Oath Appeals Board determination that the double-sided advertising sign did not constitute a legal, non-conforming use. The burden is on the petitioners to establish whether or not it is a legal, non-conforming use.
So counsel, how do you respond to the adversary's argument that the 79 permit, in fact, does permit a double-sided sign?
Well, Your Honor,
it's got it wrong.
I'm sorry, Your Honor. Yes, the 1979 permit, the DOB November 30th, 1979 permit, that permit doesn't reference a double-sided sign at all. In fact, as the Oath Appeals Board found, the only thing that's mentioned is a single-sided sign at that location. And in fact, if you look at the drawing, it was admitted into evidence, it only references a single-sided sign. So there's no reference there to a double-sided sign. And certainly, they would have to show that there was a lawfully created display of a double-sided advertising sign to establish legal creation as of the date of nonconformance. That would be November 1, 1979. That permit only references a single-sided sign, as the Oath Appeals Board found. That should end the case right there. But even if they were able to show a legal creation, they also failed to demonstrate that the advertising sign, the double-sided advertising sign, was in use continuously, except for a period of 2 years or less from the date of nonconformance through the date of the enforcement action here. The Appeals Board correctly determined that the evidence was insufficient to show that legal nonconforming use. The Thur-Young affidavit was not sufficient. The conclusory allegations in that affidavit were not sufficient to show, lacking any documentary evidence or any other evidence, that they were insufficient to show that there was a legal nonconforming use.
Factually, my recollection is that the original sign was a sign on a roof, correct, counsel?
Yes, on a building.
Now, and then subsequently,
Opposing counsel, microphone.
The subsequent sign, the building was demolished and the sign was in the vacant. Does that make a difference?
The building was demolished. The rooftop sign, it was January 2008, I believe, was the operative date. It would certainly make a difference because now you have something completely different. You have a monopole sign structure on the property. So there was a vacant land. Then they erected this sign structure. Apparently, there were permits issued in the end of 2009, and apparently this structure went up in December of 2009. It certainly makes a difference under the zoning resolution because they can't show that this was consistent with what was here before.
It was the 2-year mark.
The 2-year bar applies to actually not only to that, but also to before that. The 2-year bar applies, and that is to show the continuity of the nonconforming use. It applies because they can't show that there was a continuity of use from the November 1, 1979 date all the way through the summonses, which were issued in 2015 and 2017. They failed to demonstrate, and it was their burden to demonstrate, that the two advertising signs remained in place on the property from the 1980s, which was the date of their tax photo, through the commencement of the 1997 lease. And that was the lease between the predecessors to Clear Channel and Ryan Lee Properties. So although they claimed that they received permits in 2009, it doesn't matter because the board rejected their contention that they complied with the zoning resolution 52-83 by not creating a new nonconformity or increasing the degree of nonconformity. And I'd like to point out that a double-sided sign from a single-sided sign certainly increases the degree of nonconformity there. But that's not even the issue, because they failed to show that the nonconforming use of the property continued uninterrupted from the 1980s through 1997, and it makes no difference whether they erected the double-sided sign in 2009, whether it resembled the rooftop sign, because they failed to show the continuity of the use. They also failed to show the legal creation of that use. And certainly the Oath Appeals Board was well within its discretion to uphold the summonses here, because they failed to meet their burden of proof on these counts. And the determination should be confirmed. Thank you, Your Honors.
Thank you very much. The session is now closed. Have a good day.
Thank you. Thank you.
Yes, Your Honors. Again, with respect to legal creation, we are relying on the 1979 permit and then the later permit that was issued in 2009. With respect to the continuity of use, there were not only the documents we previously referenced, but the tax photo, the 1997 lease, the 2009 lease, all showing a continuity of use.
But counsel, I think what what I was struck by actually when I was reading the papers was that the use really changed substantially. It went from a sign on a building is demolished. Now it's a sign on the ground. It seems to me that the nature and the use has completely changed.
Your Honor, respectfully, the use is not complete. The use is not changed in the slightest. The use is ultimately for the same display of advertising sign, which would otherwise not be permitted under the zoning resolution. There was no increase in the surface area of the sign. If anything, the surface area of the sign as erected pursuant to the 2009 permits is much smaller than that was previously authorized by the 1979 permit. And there is no increase in the degree of illumination, which is the other standard of 5283, because both the 1979 permitted sign was indirectly illuminated, as was the case with the 2009 permitted sign structure as well. Obviously, as we pointed out and was made clear in the record, the building, there was an issue in terms of the underlying condition of the building, which required it to be demolished. What happened was that a sign was established so it would be in the same place and in the same envelope and not be higher above curb or not be closer to the arterial highway or in any way violate the provisions of 5283. I mean, that was just a response, obviously, to the conditions of the building that required the change from the what had historically been the roof sign to the pole sign.
Thank you very much, counsel.
Thank you.
That's the last argument on today's calendar. Court is closed.
I'm signing off.